Court of Appeal not only tended to take away the jurisdiction of the executive and the powers of the executive, but went beyond and failed and declined to restrain itself and completely violated the rule of proportionality in this case. How would it be if these organizations, which are created by Parliament and whose composition had to be changed by legislation, suddenly on the 27th of August 2010, suddenly find that they're nowhere, that they don't exist, that they do not have the legal capacity to carry out what they are supposed to carry out.
Mr. Abu Nasir, you are appearing for the third respondent.
Yes, my lord, third respondent.
Yes, that would be the party who would be adversely affected.
Very well.
Yes.
Most adversely, my lord, if I may add. Yes, my lord, in opposing this application, we'll be doing under 4 headings. One is that the entire application before the court is not pleaded in the petition. It's not pleaded in the petition. Secondly, my lord, the right to information under Article 35 of the Constitution cannot be litigated in the Supreme Court during a petition under 140. The right to information under Article 35 cannot be litigated in a petition under 140. My lord, thirdly, we will be arguing and hope to persuade you that your decision of 28 August on scrutiny and verification was a decision made per incuriam.
Issue number 1 is the issue of quorum. It would appear that there is a confusion as to the significance of this matter, which I think needs to be clarified. One group seems to argue the issue of quorum as if it has no consequence, as if a finding of no quorum has no consequence whatsoever, as if it were an academic matter. I think Mr. Justice Ouko, in one of his questions to us, sought to draw out that question of, is there consequence? We have had elections, 50 by-elections. We have had elections of the judge of the president of the Court of Appeal, elections of the justice, JSC's judges, representatives, and so on and so forth. This issue of quorum is not academic. It has consequences. Part of what was sought in the lower court was to find that part of the preparatory process leading to the election we expect in August, in a few months' time, was null and void for lack of quorum. So I want to suggest with the greatest possible respect that your lordships step back, take a deep breath, and worry a little bit about consequence.
When I look around me, my colleagues each representing a party. And as you said, some could be secondary petition. They each have, under the guideline you give, 4 lawyers each. Very carefully I did.
And it's only the main parties who have 4 lawyers.
All the petitioners are main parties.
Okay.
All the petitioners are main parties. Say, for example, petition number 1, they have my learned friends, 4 of them. And the same goes for each petition. I don't know why the noise is being generated. I can see a battery of governor. Is each 2-2? Or, huh?
Mr. Ngatia, the other petitioners have two, not four.
Oh, very well.
So you really have no reason to complain.
Thank you so much, my lord. Nonetheless, actually, that makes my work much easier. Each has two, they are 8, 16, or against nullification of one person. And then that one person, you limit him to 4 lawyers. I appreciate I'll be the first one to say we are living in difficult times. But surely it will be very difficult for me, and I say this in all fairness, to be able to master a defense against all the 18 lawyers when all we have is a human form. Let me say the last thing, Madam Chief Justice, because your fairness is legendary. The total time given my learned friends, all the 8 of them, is 8 hours. I have been allowed 3 hours. I would have requested you, Madam CJ, if there's any way you could, allow me at least half the time that my opponents have, so that I could at least be able to master a defense in relation to petition number 5, the primary, and the proxy ones, the 6 of them. That is all.
So if we come up with this process where the Constitution can only be amended through the basic structure doctrine, and you have an executive compliant court, what happens? I would humbly submit that the role of the court is to protect the people and ensure that the process the people have put for amending their constitution is consistently and holistically followed. Now, there is a question which has also been asked as to who are the constituent power. In my humble submission, the constituent power is crystallized in the Constitution by Article 1 stating that it is the people of Kenya. But the question you ask yourself, who are these people? And Article 257 goes to assist you in identifying those who are through the popular initiative. There are citizens of Kenya who are registered as voters. Those are the people. In America, it is different. In America, it is the Congress of the states. In South Africa, it is the provinces. But in the context of our constitution, there are the Wanjiku and the Onyango and Omar at the coast. And the